appealing the matter of the Durham Company Ltd and Durham County Council.
Yes, Mr. Vasher. Good morning.
Good morning, Your Lordships.
Before we start, can I just indicate to you that obviously we've read the papers. We have, we think, a keen understanding of what the issues are. And certainly speaking for myself, I think it's unlikely we're going to take all day. But that said, I'm sure that you've discussed with Mr. Robertson how long you think this might take, but that would be my relatively confident personal view. So we understand what the issues are, but beyond that, we'll leave it to you.
I'm much obliged. Certainly I intend to finish significantly before lunch, but maybe not instantly, then, if that's helpful. My Lords, I appear in this matter for the appellant, the Durham Company Ltd, with Miss Lygia Sepsiu. The respondent, Durham County Council, is represented today by Mr. Aidan Robertson, Queen's Counsel. We, the appellant, appeal against the order which is at core bundle. I don't know that we necessarily need to turn up every reference. I can just give you the reference so that you have it. The order is at core bundle tab 8, page 341. That is the order that we are appealing against. And we appeal on the basis that we have a realistic prospect of showing at trial that the claim for damages is based on a sufficiently serious breach of obligation by the council that the matter should therefore proceed to trial for a claim for damages. Separately, we say that the claim for declaratory relief is not merely academic, but would establish matters of continuing relevance and importance to the parties' ongoing competitive relationship in the market for commercial waste collection in County Durham. The case concerns the competitive position of the appellant vis-à-vis its direct competitor in the market for commercial waste collection in County Durham, the defendant council itself. As we develop further, it's our case that the council has been able to exploit its special statutory position to confer upon itself an unfair and unlawful competitive advantage in that market. The core of our case is that the breach or breaches of obligation by the defendant council constitute sufficiently serious breaches for the purposes of the test that I shall refer to as the Frankovich test for short. I know different labels are used in different places, but I'll use that label. And the pleaded basis of that case is as set out in paragraph 28C of our draft amended particulars of claim, and that is set out in full at paragraph 29 of the judgment under appeal, and it is probably sensible to pull up that. That is at tab 9 in the core bundle, page 359. So tab 9 of the judgment, page 359, has the two paragraphs of draft amended particulars of claim, which we sought to add to our particulars of claim at the hearing below. And it's 28C that we rely upon as our pleaded case, that this is a sufficiently serious breach to sound in damages. For the avoidance of that, we don't, as you know, it's been made clear in our skeleton, we don't pursue the alternative claim for damages without establishing sufficiently serious breach, which was 28B. Without going into covering in tiresome detail all the material which is fully set out in the judgment about the appropriate test for summary judgment and amendment and so forth, if I can just summarise up the position we say is that the appropriate course for this court is to consider whether the case pleaded in that paragraph 28C, currently only a draft, but for which we have an application to add by way of amendment, whether that draft has a realistic prospects of success, if so, to permit that amendment application and to allow the case to proceed on that basis, and that our appeal should succeed on the first limb, on the damages limb in that way. And that, in essence, that was the practical course taken by the learned judge below, as he explains in paragraph 45 of his judgment. But again, I don't think we need to pull it up. Your lordships will have seen that, where he essentially grapples with the case by taking 28C as the nub of that part of the case. Just pausing before I get into the argument, I should just note that the matter has proceeded in parallel with these court proceedings. As you will have gathered from the judgment, and you'll have seen in the bundle, my client had made a complaint to the EU Commission separately under that procedure for making a complaint. There's no issue between us as to the propriety or otherwise of those being parallel proceedings. Those parallel proceedings exist, and they have continued to move on since the hearing for the learned judge below. And I will be going to some of that correspondence because, while it's not relied upon as being true or untrue, the way in which the case is framed, both by the UK and by the Commission, is significant in my submission to some of the points that we have to make. In particular, your lordships will be aware that the way in which the procedure works, the UK is, and it's set out a little in some detail, touched on in the judgment, the UK engages with the Commission, and in the correspondence there's often reference to the position taken by the United Kingdom, but it is obvious when one looks at it in a number of places, at least some of that material and some of that argument has come from the councils. In some places it's from the direct engagement of the council with the Commission, and in some places it's analysis layered onto that. But in our submission it is important to look at the way in which that's developed. And if I will also just briefly, when we come to look at that material, highlight as it were, the figures to highlight the actual significance of this dispute in terms of numbers. We're obviously at a stage when we're not in a position to establish the amount of loss, but just to give the headline figures, when we come to it, we'll see that the Commission suggests that the council makes a profit of 6.2% on its commercial waste collections, and we have suggested in our correspondence that is well over twice our profit margin, and we suggest our profit margin is more typical. So there is, on its face in the figures that have been dealt with in those exchanges, a real financial issue. The fact that the council has been achieving profits whilst charging prices well below those of our clients and taking custom away from our clients is also, we say, strongly indicative that state aid by way of cross-subsidy is in play. At the heart of this case is an obligation which is clear and well understood. It is the obligation set out in the judgment under Article 1083, page 350 in the core bundle, within paragraph 10 of the judgment, where the judge sets out in full Article 107 and 108. And 108.3, where some emphasis has been added by the judge, sets out the obligation to notify state aid to the EU Commission before implementation of that aid, which brings with it, as it were, the corollary obligation not to grant or implement any state aid until notification has been made. There isn't an element of risk analysis built into this. If there's doubt, there is a process for dealing with that doubt by making the notification. The rule, we say, is clear and leaves little or no scope for discretion. As the judge himself says elsewhere in the judgment, the rules on state aid as they applied at the relevant time were at their heart readily stated. Yes, they had evolved in the case law of the Court of Justice in various ways that had involved some complexity, but this did not, we say, diminish the seriousness of an infringement of a part of the TFEU establishment of the European Union, which very carefully struck a balance, the provision which very carefully struck a balance between public and private sector and protected private commercial entities from the effects of unfair competition funded by public funds. Our appeal on the damages claim is put in two ways in our grounds of appeal, and the grounds of appeal are at page 18 of the core bundle. Again, to use shorthand, which, taking your lordship's indication as an encouragement to use some shorthand, ground 2 is a claim that the selectivity argument ought not to have been entertained at all at the hearing below. Ground 1 is the broader appeal that, taking into account those selectivity arguments, the judgment was still wrong. And in these submissions, I take the course we adopted below and address first whether the breaches in question constitute a sufficiently serious breach of obligation, taking into account those arguments of selectivity. So I'm going to leave till later the procedural arguments as to whether or not selectivity should or should not have been entertained at all. That's a fairly short point. If we're right on the first point.
That's fine. That's a matter for you. Logically, on one view at any rate, the ground 2 comes first. Because if you're right about that, then depending on what conclusion one comes to as to the emphasis that the judge put on the selectivity argument in the sufficiently serious part of the judgment, that might be sufficient.
Yes.
But ground 1 is the wider point, as it were, of law. And so for ground 1, you're assuming that you're wrong on ground 2.
Exactly. I thought it was easier to do it that way because by the time I've explained what the selectivity argument was that we were objecting to, I'll have got halfway through dealing with ground 1.
Okay, fine. So you'll deal with ground 1 first.
Exactly. Yeah. And I think that will take much more time as well. I think ground 2 is a fairly short, is really quite a short point.
Yeah.
Ground 3 is, of course, the declaratory relief point, which comes which is a separate and distinct point. And the headings that I've tried to break up our submissions in when preparing them is to look first at the legislative framework. The second heading is the factual framework and events in this dispute. Third, the test for sufficiently serious breach, the relevant elements. The next heading is selectivity specifically. Then heading 5, drawing together that material, considering the breaches in this case and their characterization for the purposes of the Frankovich test. And then ground 2 a separate heading and ground 3 a separate heading. So first, the legislative framework. We have a lot of material in the authorities bundle, but I think most of the relevant material, most but not quite all of the relevant material is in the judgment, and it's probably more convenient just to pick it out from the judgment if that's convenient.
Okay.
The judgment is at tab 9.
Yeah.
At the relevant time, again I take it that I don't need to rehearse the thorny story of our exit from the European Union and timings and so on and so forth. This is a case proceeding before exit on the basis of the pre-exit situation, and I'm going to use the fanciful grammar and so forth as if nothing had changed for the moment, just to make it less complicated, if that's all right. Yeah. The relevant state aid legislation starts with the provisions from the TFEU at paragraph 10, page 300. It actually starts on page 349. The paragraph starts 348, but the text starts at 349. Article 107.1 sets out the primary position that state aid shall be incompatible with EU law, and I've already noted 1083 prohibits a member state and therefore this public authority from putting into place a measure which gives effect to such aid without the EU Commission being notified in advance. And again, as I've already alluded to, a mechanism exists for the Commission to investigate potential infringements, and that's outlined in our skeleton, but I don't think the mechanics are particularly necessary. In fact, all that is necessary is that it exists, and there is some correspondence which we will look at, which is part of that process. It doesn't seem to be controversial that the Commission can and does entertain complaints and investigate, but those proceedings do not displace any existing national court proceedings. They may run in parallel. The claimant here had made a complaint to the Commission, and certain material in the bundle arises from that process. There is no dispute as to the working definition of state aid for these purposes. We've taken the definition that sorry, myself a wrong reference. Paragraph 11. The elements of the test aid in the elements of the test for state aid are set out in paragraph 11 of the judgment. First, there should be the aid is aid in the sense of economic advantage granted by the state or through state resources. 2, the measure favours certain undertakings, and that of course is a defined term in EU law, over others in a comparable legal and factual situation. 3, the advantage is not justified by the nature or general scheme of the system, or the advantage is likely to distort competition. So that then is the overall EU context.
Mr. Bowsher, that fourth point
Yes.
is something which has interested the Commission, but it didn't feature at all in the argument before the judge. Is that right?
That's right, and I'll come back to that. I'll come back to a couple of points on that.
Thank you.
Sorry, just to pick up, to make, to tie up a cross-reference within the judgment, that narrative in paragraph 11 of the judgment itself tracks almost word for word. I think I would check. There are more than one different ways of more than one way of wording these tests, but they cross-refer to the extract from this is Justice Bacon's textbook, European Law of State Aid, which is quoted in paragraph 22 of the judgment. There are sometimes, I'm not going to worry about whether it's exactly the same. It's similar and covers the same territory.
Okay.
Can I turn then just to look at the statutory framework that covers the relationship between the parties, which of course is the provisions of UK domestic legislation, and they are to be found in the authorities bundle. They're also in the one or two bits are missing, I think. The authorities bundle, tab 1 has the Environmental Protection Act. It's paragraph 5 of the judgment, but page 14 of the authorities bundle. And for this purpose, I don't think it is contested. The defendant is a waste collection authority. That is the defendant's case. It is therefore required by statute, that's by 45(1)(a), read with 45(3), to arrange for collection of household waste without making any charge for that service, subject to certain irrelevant exceptions which we don't need to engage with. This case concerns the collection of commercial waste. The defendant counsel is also obliged to arrange for, and that's important, to arrange for the collection of any commercial waste from premises within its area upon its being requested to do so. This comes out of 45(1)(b) and 45(4). It is entitled to make a reasonable charge for the collection and disposal of that waste. There is no explicit definition of reasonable, but we submit that reasonable must be read as meaning both reasonable and lawful.
And where does that come from?
Sorry, reasonable comes from 45(4).
45(4).
45(4). It is
A reasonable charge.
reasonable charge.
Yeah.
So there is therefore no obligation on the defendant to actually arrange for the to actually collect the waste, whether household or commercial. It is obliged only to arrange for the collection. So it does not have to be. It is not required to actually be the entity that goes out and does any of this collection, but it must arrange for either household or commercial waste. Of course, some commercial waste will not be dealt with through this system at all, because some commercial entities will simply call some other entity to do it. They're going to be charged, and they may decide, I'm not going to call the council today, I'll call, we would hope, my clients would hope they would call them, without having to make the request for the council. The council can choose to undertake the collection itself and satisfy its obligation that way, but or arrange for others. But for the purposes of the Act, when it is actually carrying out collection, the actual business of collecting waste, it enjoys no special status distinct from any other entity carrying out collection. It is just another undertaking carrying out the collection of waste. All that is special about the defendant's position is that it must arrange for the collection, that it may not charge for the collection of household waste, and that its charge for commercial waste is limited to a reasonable charge. It is for it to decide who carries out the actual collection. And we don't understand it to be in dispute that other local authorities do engage third-party contractors. This comes out in the pleadings, which we'll come on to. Other well-known household names, Veolia, Biffa, so on and so forth, do carry out the collection, and I don't. Perhaps not a matter properly for judicial notice, but certainly the lordships will have noticed it on the streets. The council pays for the collection of household waste from other revenue, from its other general revenue. It cannot charge the occupier or waste producer for that service, and the assets that provide that service are not paid for by charges for waste collection, but by the other general revenue. So that is the legislative structure. Turning then to the factual framework and events in this dispute. The defendant has chosen to undertake the collection of household waste in its area itself. It has also chosen to undertake commercial waste collection in its own area itself, to the extent that it can do so using the same equipment it uses for collection of household waste. And your lordships may have picked up that essentially, if the commercial waste is in a skip that can be used on the back of the same collection vehicles, then it picks it up. If it's in some other receptacle and can't be picked up by its household waste vehicles, then it will arrange for others to do it. So it only picks up the commercial waste if the commercial waste can be picked up by its household waste assets. The defendant admits that it acts as an undertaking for the purposes of Article 107 when it provides commercial waste for a fee when acting under its duty under Section 45, and that is in, sorry to probably close the authorities for a moment and go back to the core bundle, that we can pick up from the amended defence, which is at tab 13, and if we go to page 416, paragraph 25 C1,
It is admitted the defendant acts as an undertaking when it provides commercial waste services for a fee.
Indeed.
Yeah.
There, in some places, there seems in this pleading to be some elision of the obligations to arrange for waste and the actual collection of the waste. See the way in which it's put in 26B, where it's pleaded that the defendant has a duty to collect household waste. Well, we've seen, and a duty to collect commercial waste, we've seen that that's not strictly right, but I'm not sure the point matters particularly, save to note that there isn't a, it goes back to my point, that the collection activity is not an activity that is carried out directly pursuant to statute. The collection activity is something which the defendant must arrange for, but is not required to do itself. So 26B may not be strictly right, but that may matter when one's looking at the particular status of the defendant. I don't think I need to labour it too far then. As can be seen, and it comes up again and again in different parts of the pleading and in other materials, the assets used for commercial waste by the defendant are the same as those for household waste, and their principal activity is the collection of household waste. The capital cost and running costs of those assets are therefore largely covered by the household waste activity and its revenue. And plainly, those costs are largely covered by that activity. There's no evidence available at this stage in the proceedings as to how any allocation of cost for the purposes is to be made, although there's reference, which we'll come on to in some of the commission correspondence about how that might be done. But there's no actual evidence before the court on that point. At least until the end of 2019, so well after the period to which this claim relates, because it goes back to cover substantial earlier periods, at least until the end of 2019, no separate accounts for the two activities were prepared, so there is no basis for identifying how such matters were or might be allocated. And we can again pick that up from the defence. It's in core bundle. We have the defence open. It's paragraph 12, which is on page 412. Is that right?
Paragraph which? Paragraph 12.
Oh, sorry, it's on page 413. It's in paragraph 12, and it's actually the first. This is a quotation from a letter which we'll come on to, and it's the first quoted paragraph at the top of page 413.
Yeah.
We'll come on to this letter itself, but this has been incorporated as part of the defendant's defence.
So they say not separate accounts and no obligation to.
Indeed. Sorry? Yes. It is not. There is. It seems that some separate accounts. There is an expressed intention by the council to start preparing separate accounts from around the end of 2019. It is not apparent from the papers when that may have started or whether it's actually been done. I don't think it matters particularly, but there's the court simply doesn't have that evidence. There is some reference in the defence at 27A to these separate accounts having been put in place retrospectively for 2019-2020. That's paragraph 27A, but it's not entirely clear what that means. The nub of our case is in the summary of the particulars, going back to the judgment at page 3, going back to the judgment, which we can find the relevant passage at page 351 of the bundle. The nub of our pleaded case is summarised by the judge in paragraph 12, page 351. I don't propose to repeat all of that. And the nature of the loss, which is referred to in that summary, is underscored by the evidence from my client's solicitor in paragraph 7 of the judgment, which is quoted by the judge on page 346 in paragraph 7. And she says, the quotation there, the claimant has informed me that the prices offered by the defendant are simply unsustainable for a private company, given the costs and overheads involved in waste collection and disposal. The claimant is not able to compete with the defendant on price despite having attempted to do so on countless occasions. The claimant believes that the reason the defendant is able to offer such low prices and therefore win business is due to the fact that it utilises the same infrastructure and resources for collection of commercial waste as it does for household waste, infrastructure and resources which are at least in part, if not entirely, funded by the taxpayer. The last sentence is about a tax advantage which has been the subject of separate proceedings. There's also some discussion about in the documents about another issue which was raised about access, differential access rights. That doesn't arise in this claim, but it is a point that has been made by my clients in other places, but it doesn't arise in this pleaded claim. So that's our claim and the loss which we say we are entitled to compensation for on the basis that the breaches engaged are sufficiently serious. There are some important matters of common ground established at page 352, paragraph 14. I don't propose to read them all out, but we've probably covered most of them already. But the key point is that as the council is an undertaking, it is therefore admitted that the provision of support by the council to its commercial operation, providing waste collection, gets over the first threshold limb of the state aid test. This, if support is being given by the council to its commercial waste operation, that is support to an undertaking, and that gets one into the discussion of the subsequent limbs. And that commercial operation, the undertaking, competes directly against the claimant in the commercial waste collection market in County Durham. And our pleaded case, as set out in paragraph 26 of the particulars, page 2, going back to our particulars at, so that's wrong. Page 397.
So these are the unamended.
These are the unamended particulars.
Yeah. Paragraph 26.
Paragraph 26, and the key inference on which we say the case is based is D, which goes on to which is at the top of page 398. In light of the previous material in that paragraph, the claimant infers that the defendant's business was able to set its annual charges for commercial waste collection services at the levels referred to because it was not required to bear any of the market costs of providing those commercial waste collection. Alternatively, it was required to bear only a part of the market costs of bearing those services. We don't know. We don't have the details. We don't have the accounts. We don't know. But that's the inference we draw that a substantial part of the capital cost of the assets and so on and so forth, the fixed costs of providing the commercial waste service, is being borne by another part of the service, and that is a state aid. The council's pleading to that is at paragraph 217 of the amended defence. paragraph 27, which is at page 417. And again, which is really just a denial that there was any need to plead separate accounts. And 2060 is simply denied. And that is all that is said in response to our pleaded case at that point. Our case overall, in the particulars, is brought together at paragraph 28, where we go through the limbs of the state aid test. Again, I don't think I need to read them all out, but from 28 to page 398 of the core bundle, and we plead support from state resources to an undertaking, selective advantage, distorts competition, and then E, these arrangements affect trade between member states as a number of undertakings established in other member states are active in the provision of commercial waste disposal services in the United Kingdom, e.g. Veolia, Suez, Remondis and FCC, and in particular in County Durham, Veolia, Suez and Remondis. And the response to that is at paragraph 30C of the amended defence at page 418. There's a denial of the effect on trade member states in 30B, but it is admitted that operators of commercial waste, 30C, bottom of page 418, it is admitted that operators of commercial waste disposal services available in County Durham include businesses operated under the Veolia, Suez and Remondis brands, which are ultimately owned by businesses based in France and Germany, I think, respectively. And that picks up, at least by glancing blow, part of the point about it was raised by Justice Edis. The question is that there is a reference in the case to the effect on trade with member states. Yes, issue has been joined. It's been denied by the defendant that there's an effect on trade with member states, but there's also an admission of the facts on which we rely to show that there was an effect on trade between member states. Now, at the very least, we would say that is the question whether or not the involvement of those companies owned by non-UK EU-based entities at least raises the question about whether or not there was an effect on trade between member states. And certainly would suggest, we'll come on to this, that this is not a merely local effect. I mean, this is not purely only a matter of interest to the people of County Durham. Someone in France and Germany is also monitoring what is going on, presumably in the offices of Veolia, Suez and Remondis. Or was anyway. Certain other factual matters are worth highlighting, arising out of the subsequent correspondence between the EU Commission and the claimant. There's quite a lot of material in the bundle which goes back before the proceedings started from various exchanges arising out of Freedom of Information Act requests made by my client, but I don't think we need to deal with the detail of that now, because most of the key points have now emerged either in the pleadings, the judgment, or in the subsequent correspondence. But what is useful to look at is the correspondence between the claimant and the Commission, starting with the letter at page 43 of the core bundle. from the Commission to TDC, the claimant. I think it's purely a coincidence. That letter is dated the day before the judgment below was handed down. So the judgment already existed in draft and had been circulated to council, but was handed down sometime first thing the following morning.
Sorry. Yeah, I think you drew it to the judge's attention on the 27th.
Well, we had a consequentials hearing, didn't we? That was right. Yes.
The
The judge was aware of it.
Costs.
That's right. The judge was aware of it at when we had a consequentials hearing after the hand down. Isn't that right? Yes. Thank you.
But not aware of it at the time of the judgment.
But not aware of it.
Given
at the
that
time.
he turned the judgment round in a week, all power to the judge.
Yes.
So he hadn't seen this letter at the time of the judgment, but it might have been referred to in the consequentials hearing.
Indeed so.
Okay.
Um,
So what are we looking at particularly in the letter?
The Commission is responding to points made to it, and its understanding of the facts is set out at page 44, reflecting what has been conveyed to it, or what it refers to as the UK authorities. The paragraphs 3, 4 and 5 bear reading. They say they, the authorities, have indicated they can determine the average weight of waste on collection of the different size of bins and how they can determine the share of commercial waste collection in their total activities, and thus allocate a proper share of the fixed costs to the allocation to the collection of commercial waste. The authorities provided a detailed financial statement showing costs and revenues for commercial waste collection. The costs also include a share of personnel and all fixed cost items that the Regeneration Department, dealing with commercial waste, shares with the collection of household waste, including fuel costs. The financial statements show a rate of return of 6.2% for activities in relation to commercial agreements, which would not appear to constitute an excessive profit. In addition, we would like to inform you that the UK authorities have clarified that Durham County Council keeps separate accounting for the commercial waste business in place in order to distinguish the residential from the commercial waste collection operations. Furthermore, the UK authorities have indicated that they ensure that local accounting officials are aware of the necessity to keep separate accounts, distinguishing commercial waste services from those relating to the management of public or household waste collection services. Now, it may be that that statement is consistent with the defence, because it may be the reference to existing accounts is only over this period after the end of 2019. But it does seem clear from this that the Commission's approach to a proper understanding as to whether or not these circumstances gave rise to a breach of the state aid obligations was to look at the separate accounting for the two businesses and to use its phrase to see whether or not there had been a proper share, whether or not the defendant had allocated a proper share of the fixed costs to the collection of commercial waste. The thrust of the Commission's analysis is on all fours with what we say is the correct analysis, but one needs to look at whether or not the defendant's commercial waste undertaking is bearing its proper share of those costs. And if it isn't, we would say the corollary of that must be that there is a breach of the state aid regime. Now, the answer the Commission is saying is essentially saying we've been given some material which is certainly not been provided, was certainly not set out in the defence, and while the two positions might be consistent, they sit together, they're ill at ease together, because as you'll recall, the position to us was we're not required to give accounts, and we haven't done so at least up until the end of 2019. Whereas the position here is the Commission has been told, no, we've got lots of analysis we can do, and from that we can show you what a proper allocation is. There is something strange here, we don't know what it is. So two matters flow from this. So firstly, as I said, the first point is the preliminary assessment of the Commission seems to be based on a position regarding the existence of separate accounting, and that the understanding by the Commission of the merits of the case is based on an assessment of the allocation of proper share of costs, and that is, we say, the nub of our case. Now, we dispute that it has been done. We say there's a dispute of fact to be looked at, but at the very least, this very strongly supports the view that there is a real issue to be looked at as to whether or not there's been a breach of state aid obligations. I'll come on to whether or not it's sufficiently serious, but it's not a breach that can simply be lightly dismissed as something that the council took a view on and decided it was appropriate to move forward. On the contrary, the position that is expressed to the Commission suggests that there might have been some analysis, but it's analysis which, in these proceedings, the county seems happy to deny has ever been done or it was ever obliged to do.
Can you explain one thing to me? I don't think it's actually terribly germane to the central issues in the case, but you are placing emphasis on allocation of costs. Do you say it's illegitimate for the council to take into account the fact that it already has the necessary infrastructure for other purposes? Because the implication of your argument appears to be that it's illegitimate and therefore the council ought to be charging higher prices, and therefore your argument is not that the profit rate of 6.2%, which you earlier said was high, is high. In fact, it's too low. They should be making a greater profit.
I'm not. We've done a different figure on the numbers, but let me take the primary point. What is or is not a proper allocation is not something we've engaged with in detail, but in principle, we say that there should be at least a proper attempt to allocate the fixed costs of the commercial waste, of the assets, insofar as they are used for the commercial waste business. Now, we haven't got into that detail in this case, but if, for example, they simply don't allow for any fixed costs at all, they simply take, for example, all the fixed costs of all the vehicles as being covered by household waste, then that would be illegitimate. I take your Lordship's point that there may be real accounting questions as to what you deal with, how many, if the question is, well, we might have needed 70 for the household, but because we're doing the commercial as well, we need 80. Well, maybe that might be easy because you can look at the additional 10. It may be, but of course it may be more complicated than that because of the way in which the commercial waste and the household waste is done, and it may not be simply a case of one additional vehicle to deal with some additional business. So I'm rapidly getting into an area of accounting that was probably beyond my amateur accounting facilities. So I'm not saying that you simply ignore the fact that the assets already are there, but you certainly don't compete in the commercial waste business as if you can, as it were, have a free ride, if that's what is being done, on the assets which have already been bought for the household waste. No, sorry. So the council should be bearing greater costs, charging probably higher prices, but perhaps at lower profit.
Well, that depends, as you've just said, on how the costs are accounted for.
None of which we know, and you've seen that. You've seen in the defence that we've said the parties have set out the position they would take if these proceedings were to go ahead. We've said what we would like to see on disclosure, and they've said we're not having it. So I mean the lines of battle are there, but I don't think we're not at the position in this case yet where that sort of material is available. I'm not saying that any of that's not relevant. It's just we've not got to that sort of level of analysis. At the very least, whatever the truth of the matter is, the court cannot sensibly assume that we're wrong on this point without evaluating the underlying evidence, given that there clearly is more to this story, to put it in the vernacular, there's more to this story given what's being said in the Commission letter than one sees in the pleadings. The Commission does not reach its provisional view, and this is important. The Commission does not reach its provisional view in this letter on the basis of any lack of selectivity. There's no suggestion here that lack of selectivity is the issue. Quite the contrary, in fact. It approaches this case very much on the assumption that there is selectivity. Otherwise, the whole question of proper allocation of costs wouldn't make any sense. It's not the sort of letter which explicitly goes through the legal analysis, but it jumps over that immediately and gets into the facts as to whether there is or isn't a proper allocation. It says that on its preliminary assessment, in the third para of page 44, that on its preliminary assessment, it has not been led to the conclusion that there would have been cross-subsidisation between the two services. And as I've said, that seems to be based on material which is either not available in these proceedings and either inconsistent with, or at the very least, not readily made consistent with the material that already is in these proceedings. At the very least, there's a serious issue. A lot of material was then sent by those instructing me in response to that letter, and that appears from page 55 to 300 of the core bundle, and I'm certainly not intending to go through very much of that.
So this is all post-judgment?
This is all post-judgment. It's a parallel legal proceeding going on between the judge. It is an odd situation, but...
But I mean, for the purposes of this appeal, this is all post-judgment? Indeed it is.
We're not relying upon it as being true or otherwise, but it is important to understand the party's position in my submission and to see how what is important from that material is just to pick up the reiteration of the county's position at page 74. It was a letter, part of the material that was sent back to the Commission, 12th of April 2017, and just the county reiterates its position that it doesn't keep separate accounts. And that's reiterated again in the letter of November 2019, again another letter from the county at 77. And that's, sorry, the actual relevant passage is the two paragraphs on page 78. The council does not accept that this is under, and this is odd. So the 7th of November, it's writing to us, the council, it does not accept that it is under an obligation to keep separate accounts, nor does it accept that any suggestion that a failure to have separate accounts in some ways amounts to an unlawful state aid or is evidence of the same. And this is where we picked up the reference that there seems to be an indication that something is going to be done.
So this is all under cover of your instructing solicitor's letter of the 23rd of December 2020, which is over a year ago. Has
Yes.
anything further happened since then?
Yes. The final response of the Commission is now in the supplemental bundle at page 155. That's the letter of 16th of June last year. Page 155. First, just to frame this letter, it is as it were the Commission's final response, but page 156, penultimate paragraph, is the paragraph starting disposition. It's not a definitive position of the Commission as an institution, so it's not a legally binding letter. It's not a decision to the UK. It is simply, as it says there, a letter from the services saying what they currently think. It is a preliminary decision, but it does not suggest that it relies upon all that's gone before. It doesn't contradict what's gone before. The point it adds, as has already been referred to, is the point that it is made at the top of page 156. Again, I wasn't proposing to read it all out. Those first three paragraphs all go to the general points, which starts, in addition to this, the alleged infringement would in any case have only limited impact on the functioning of the internal market. And then the third paragraph started, based on the above elements, the collection of waste commercial waste appears to be very limited and of a purely local nature. Again, that's all subsequent to the judgment, but we say hard to reconcile on its face with although the defendants have denied an effect on trade between member states, at the very least the fact that substantial entities based in other EU member states at least raises a question as to whether that's the correct position. But that then is the end of the matter, save that those instructing me do send further correspondence in response to that.
July.
Yeah. And that's where we seek, and there's an analysis in there. It starts at page. We address the trade on member states point on page 160. And some of the other points that have been made. I mean, I wasn't proposing to there's clearly a lot of factual material in here, but that I think brings the matter between the parties and the Commission up to date. I don't think that anything has happened since then.
Thank you.
You haven't been informed under Article 4 of the Code of Good Administrative Behaviour for staff of the European Commission in their relations with the public that the correspondence has become repetitive or pointless.
No, not as far as I'm aware.
Could that sound any more pompous? Yeah.
I make no comment.
Okay.
In short, the Commission appears to have accepted assurances that there is no cross-subsidisation, whatever the problems that may whatever material is being relied upon. That material is not material that was before the judge. The issue as to whether or not accounts have to be kept or have been kept was not in that sense before the judge. And as we've said, I will say it again, but then try not to repeat myself. The approach taken by the Commission is very much on all fours with the analytic framework we've adopted. Is there a proper allocation of costs? the relative figures, again, of the different levels of profit come out of that correspondence. But again, they are, from our perspective, they are trying. It is a comparison with on the basis of material, us trying to construct a material around what we've been given. But that is in our, goes back to the November and December correspondence, and in the December correspondence, that's where we set out our position as to what we thought the appropriate profit margin should be. But I don't think I need to point out it's significantly less than the council's. So overall, the better prima facie view must be that there was the grant of state aid, therefore a breach of obligation. The judge assumed that the claimant had a realistic prospect of establishing a breach of that obligation, explicitly says so in his judgment, and in so doing he must be taken, as we say, he must be taken as assuming that there's a realistic prospect that a lack of selectivity does not afford to a defence to the claim, and that there is sufficient effect on trade between member states for the obligation to notify aid to be engaged. The only point he engages with is essentially the selectivity point, a point which the Commission has not engaged with at all. Turning then, the next heading, to the Frankovich test and the relevant elements. I'm not sure that I don't propose to spend a lot of time going through all of the case law, because I'm not sure in terms of where we are to find the test, there's a great deal between us. As I've already said, we rely upon paragraph 28C of the proposed amended particulars, which is set out in the judgment. The real issue is not what the test is, but how it is to be applied here, in particular whether the position of the council under the Environmental Protection Act affects the seriousness of the breach by reference to the relevant criteria. Is the council under some sort of special in some special situation? And as I've already said, we say no. The factors are those set out in the passage in Legacy, which is quoted in the judgment at paragraph 52 of the judgment. So going back to the judgment at tab 8. Paragraph 52, those factors are set out from the Legacy judgment, but they go back to earlier case law.
They go back to fact attainment.
They go back to fact attainment, exactly.
Yeah.
Sorry.
Yeah.
And they are, I won't repeat them all now because they're now well known, but they are 1 to 8, and I'll use those labels 1 to 8 from the judgment. There was some discussion, and there is some discussion in the judgment as to whether the consequences of the breach are relevant to evaluating the seriousness of the breach. Plainly, the test addresses the seriousness of the breach, not the consequences directly. And so one looks at the breach, not the consequences, at least to start with. But as the judge acknowledged, this distinction may not be of a great deal of substance, because plainly the consequences of a breach will be relevant. A breach without any consequences is at the very least less likely to be serious. And factors 5, 6, and 7, the intentional action, behaviour of the infringer, and position taken by persons affected by the breach, all of those contemplate that a breach has consequences. At the very least, the way one looks at 5, 6, and 7 will depend to some extent upon how the infringer and those affected by the breach are affected. They do to some extent bring in the consequences of the breach. Excuse me. taking Negassi as the starting point for this, for the discussion as to what the test is. Negassi is at tab 7 in the authorities bundle.
Do you want us to go to that?
Yes, please. Yes, sorry. Tab 7, it's at page 131, tab 7.
Yeah.
I think we don't need to get, although we sidelined the facts in some detail in the judgment, I think maybe that was probably a little over-enthusiastic. I think one probably gets enough from the head notes to know that what the case was about.
I'll take over enthusiastic. Yeah.
The key part is paragraphs 14 and following. And the point, of course, as is plain from that case, is that the breach in question turned on a failure in the process of transposing an EU law measure into domestic law. And as Negassi makes clear, in such a case, the seriousness of the breach raises questions as to whether the domestic legislator was acting in an area where there existed a relevant measure of legislative discretion, where there are choices to be made into how the EU directive, the EU provision in that case was brought into domestic law, and that discretion and the way it was exercised may or will be relevant in deciding whether the breach was sufficiently serious. And there's a long discussion in Negassi about the uncertainties that there had been over the relevant EU law provision before it had been clarified by case law. But the starting point for the court in the judgment of Lord Justice Morris case, starting at paragraph 12, is that a failure to transpose an EU directive is likely of itself to be a serious breach. So where there's a legal obligation to do something, transpose a directive, and it's not done, that's likely to be a serious breach. Where there is something more akin, as in this case, to a bona fide, as in Negassi, sorry, more akin to the bona fide attempt at transposition, referred to in paragraph 13, that becomes the classic instance of legislative discretion in a difficult area, and that is where the court has to look at whether or not if it turns out to have been a breach of obligation, whether or not it's sufficiently serious given the fact that the legislator was exercising that discretion, that choice in making the implementation. But even in those cases, and in that case particular, as we see from...
Sorry, why is the case law on transposition of any relevance at all to our case? We're concerned with provisions that have direct effect. There's no requirement of transposition. And transposition is all about legislative choices, as you're rightly saying. This is not a case about legislative choices. This is about commercial activities, whether they amount to state aid or not.
I'll move on to my next paragraph. I would agree. Negassi is taken... It's taken by the judge, and it's taken, I think, more generally as the most current overarching statement of the Frankovich test. But we would, when looking at whether or not a breach is sufficiently serious, one looks at, we would say, a continuum, and the opposite end of that continuum is identified in cases such as Headley Lomas, which is at tab 9, decision of the Court of Justice, in paragraph 28 of the judgment, which is sidelined at page 247. We would say that's the right analysis. It's 247 of the authorities bundle, paragraph 28, and we would say this case is much more akin to that.
Sorry, which paragraph?
Paragraph 28. as regards when at the time when it committed the infringement, the member state in question was not called on to make any legislative choices and had only considerably reduced or even no discretion, the mere infringement of community law may be sufficient to establish the existence of a sufficiently serious breach.
But is that saying that you don't then look at the 8 factors?
No, I don't believe it does. It is.
Or are you saying?
I'm not saying
I mean,
that.
what I'm trying to get clear is there are the 8 factors. After that, isn't it all a matter of fact and degree in relation to each of those? Some of them may not apply at all. Some of them may be very important. It all depends on the case.
Yes. Which is why our case is not really based on a detailed analysis of lots of case law. It is really, I'm trying to set out the framework, and then we have to look at the breaches. But we say this is very much at the opposite end of the spectrum, where there isn't a degree of legislative discretion. There is a legal obligation which the council must comply with. Now, it may be difficult to know whether or not they may require some analysis on its part as to how to deal with the matter, but there's a notification process. They can deal with that. They have a clear legal obligation, and it's really not the below, as the judge points out in his judgment, there was some weight was put by my learned friend on the fact that in Headley Lomas the court says the mere infringement may be sufficient, does not say must be sufficient. And I think that is the signal that it's not a bright line test. It is not that there's a situation where the factors go out of the window. And plainly the court did not say must. But we would say in a case like this, in this case, the infringement is sufficient to establish a sufficiently serious breach on its own. Other factors come into play as well, but that is sufficient of itself, because, as the court has said, the Court of Justice there said, mere infringement may be sufficient, and we're in that sort of situation, at that end of the continuum. Where there is no discretion in play, the first 4 factors, at the very least, must be very much less significant and have little or no active role to play. I don't think I can say on the authorities that they are irrelevant or not applicable, but they become almost inoperative. Where there is a legal obligation upon the public body, it must expect to comply with it, and if it is not a matter of choice whether or not to do so, even if the measure is unclear, once it has been established that it has been breached, the likelihood, if not the certainty, must be that it is a serious breach, unless it can be shown for some other reason to be trivial. Ignorance of a law which applies without application of discretion is not an excuse and should not be a defence to what would otherwise be an available remedy in normal circumstances. And to give another example of a case at the other end, and it is just an example, it is just to illustrate the situation at the other end of the spectrum, we've put in the authorities bundle the case of Hochtief, which is a procurement case. It's in the Court of, again in the Court of Justice of the European Union. The facts are quite excessively complicated because the Hungarian legal system got quite tangled. There have been various decisions. But the short point one can gather from the footnote at page 249, 4th line, the claimant company challenged the lawfulness of that criterion before the arbitration committee. What was the criterion? It was a criterion which included a criterion, it's in the previous sentence, regarding the candidate's economic and financial capacity. And the challenge was that that was a discriminatory criterion. And the Court of Justice, after dealing with all sorts of other issues, decided that paragraph 43 of its judgment at page 289, an infringement of EU law is sufficiently serious if it was made in manifest breach of the relevant case law of the court. And to take the procurement analogy a little further, where one was dealing with something which plainly infringes a treaty obligation such as discrimination, equal treatment, transparency. Again, at least I've discussed, caused to debate some of these points in the past in other cases. Those are treaty obligations which one would normally expect to be automatic, sufficiently serious breaches. Now, just staying on public procurement for a moment, just to illustrate why we probably still are in a continuum, and why, because I think it would be, public procurement perhaps illustrates why this is a continuum, because as your lordships may have encountered, there is a lively debate in the domestic case law about whether some or all breaches of public procurement legislation are sufficiently serious breaches to give rise to damages. The line is not yet clearly drawn, but I think it would be fair to summarise to say that there is probably some area of manifest error in evaluation while an authority is exercising an evaluative discretion, so not a legislative discretion, but a discretion in evaluating bids, for example, that some of those breaches might not always be sufficiently serious. Now, I'm not going to get into whether that's right or wrong, but that is a live debate in the case law, and I know certainly my Lord Justice Coulson will be aware of that lively debate. And in a sense, just the very existence of that debate probably illustrates, at least in the state of the case law as it is in this country at the moment, we are talking about a continuum, because there probably is at least, I'm sure there are other categories of case where there is not a sufficiently serious breach, but I give that as an example, even though we're not talking about a legislative discretion. But that's clearly not this case. It can't be said that the council was exercising some appropriate statutory discretion in deciding whether or not it was or was not in breach of its state aid law obligations. Those were treaty obligations fleshed out by other legislation, and if it was in breach of them, it was in breach of them. Again, the situation may be difficult, and it may take advice, but it cannot make choices and then say, well, we've made the wrong assessment of our legal obligation, but it wasn't too bad after all. There is no discretion here. Now,
so if, as I understand the submission you've just made, you say it's a black and white case, and if it's black, it's black, it's white, and that's the end of the story. And the logical consequence of that would surely be that there would be lots of cases in which Frankovich damages have been awarded for breach of state aid, because it's black and white. So in every case in which there's been a breach of the state aid rule, there would be a claim for Frankovich damages. And yet there are none. So how do you explain that?
Well, I think when it has been contested, it is usually, I think, being contested through either commission proceedings or, at least in this country, through judicial review or threats of judicial review, and changes have been made. It may very well be that the short answer is that the United Kingdom authorities are scrupulous and generally reach correct analyses. I don't think one can say...
Can you point to a single decision anywhere in the EU? Anywhere in the 28 member states as were?
Well, I can point to the Brussels decision, which is not a damages decision. But
no, it's not. That's my point. Can you point to a single one in any member state over the entire decades since Frankovich was first decided? Just give me one.
I can't, but what I can say is that the Commission contemplated that damages would be available.
To be sure, that's not in dispute, that theoretically it's possible. But has it ever been done? And as I understand it, the answer is no.
I don't believe I believe the answer is no. But there's plain, we have it in the paper, sorry, I can't now, I've got a blank as to where the reference is. But the Commission contemplated that damages would be a remedy. We would say this is a black and white breach. If it's a breach of law, why? And there is no there is no discretion as to whether or not to comply or not, then it seems to us, we submit that this must be a case in which this must be a sufficiently serious breach. There can't be a general position that because cases have not been brought in the past, it is not sufficiently serious now. It's difficult for. I mean, I don't think it's proper for me to sort of speculate as to how markets in different places may have operated. When from a personal perspective, when state aid has arisen, generally it has been in a case where one has been offered to make a fairly prompt challenge to stop the state aid going ahead in judicial review. But that doesn't mean that damages shouldn't be available. There's nothing in the law that says damages should not be available, and there's nothing that says damages that if it is a breach, that it should not be sufficiently serious. If it's sufficiently serious to give rise to a judicial review remedy, and there's no other reason why such as legislative discretion, why the breach is not sufficiently serious to stand in damages, in our submission, that it ought properly to be treated as such.
The difficulty here is that, of course, the breach is being assumed.
Yes.
So we're assuming a breach. The judge, as you say, rightly assumed there was a breach. So it then becomes, if it is black and white, it then becomes potentially artificial to say, well, we're assuming a breach, and what's more, we're assuming that as a result of that assumed breach, this must be sufficiently serious to warrant Frankovich damages. You see the point. I mean, I'm not sure ultimately in whose favour that point goes, but it is a potential artificiality of the issue before the judge and before us. We're assuming a breach, and then we're assuming it's sufficiently serious because it says a breach.
Well, you're assuming a breach, and for us to win, you would have to find, you're not assuming that it's sufficiently serious, but that we have a realistic prospect of showing that it is. Not that assuming that you don't have to assume that it is.
We'd have to find that you had a sufficient prospect of success of showing that it was sufficiently serious.
Yes.
But since it's an assumed breach, in one sense, it's quite difficult to do that.
Well,
because we're all used to looking at a breach and then saying, well, is that breach sufficiently serious?
But that is a function of where we are in these proceedings.
Oh, I understand that.
I'm reminded, my learned juniors, can I just take one step back to
address,
particularly to try and to cover this point. I'm reminded where we have the material. In our skeleton, we've actually quoted the Commission's notice on enforcement of state aid law in national courts. It's at paragraph 18 of our skeleton for this appeal, page 314. Mm-hmm. And that, we've added the emphasis, but that notice by the Commission, and this is a soft, I'll call it a soft law measure. I mean, it has more status than the Commission's letters in this case, or had at least at the relevant time. This is a statement by the Commission, obviously dependent on national legal rules, that envisaging that damages claims can be brought. Now, the lack of them, I'm not sure that, again, at this stage of the proceedings, one can properly draw any proper legal conclusions from the lack of any claim. There may be any number of reasons why that may simply be that other remedies have always been more useful. It may be that in some countries, state aid has always been, compliance has been a higher standard, or people aren't prepared to take the risk of bringing claims.
We are in a situation where the Frankovich jurisdiction has existed for decades. The law on state aid has existed for decades, and yet there is not a single case in which, in any member state, in which it has been found that a breach of the state aid rules was sufficiently serious to attract the Frankovich damages, not one. This would be the first one.
As far as I'm aware. But that would not be the only area. I mean, it is not unusual, for whatever reason, for cases to be rare. I'm going to give you another, going back to public procurement, maybe my home turf, as it were, but give you another. We've been talking about damages claims being available for breach of EU law obligations in England ever since 1991. Since then, no English court has actually made a final judgment of damages. Lots of claims have been made, lots of claims have been settled. Findings have been made about sufficiently serious breaches, but they've all been settled. No one's actually had to get to the end of the process. There are often reasons why there are relatively few such claims. And since then, I think in the entire period, there's been one in Scotland and one in Northern Ireland. And that's it's a different point. But you can have an area where there may be vigorous litigation and vigorous disputes, but for some reason or other, that remedy has never finally been vindicated, just because of the way in which the regime operates. I mean, in taking public procurement, it was many years before any claim was brought at all for damages. So, in my submission, there's no proper legal inference to be drawn from the factual lack of any such case law. Maybe they're all settled. I don't know. One simply doesn't know. Certainly, I don't. I'm not in a position to make those submissions. I don't know whether others do know. Sorry. And my Lord, picking up Lordship's point, my Lord Justice Coulson's points. I think I would just wrap up my response to that to say, all of your Lordship's observations simply highlight why it is difficult to deal with this matter at a strikeout or in the strikeout summary judgment context.
Well, that's why I said I didn't know ultimately in whose favour that observation was.
But it's not a reason in my submission why this case should be brought to an end simply because it will be difficult. Just because it will be difficult does not mean that the case should be brought to an end.
Did the judge say what breach he was assuming? I think all he said in paragraph 55 was that he was assuming a breach.
I think that is right. I'm not aware of any fuller statement than that.
No, I don't think I am either.
My Lord, it's my learned friend's claim that there was a breach of the duty to notify aid to the European Commission. So that's the only breach that's pleaded. That's the breach that the judge was therefore assuming.
Yes, I get that, but obviously underlying that is what was the aid about which there should have been notification.
Well, I presume more broadly, I may be reading too much into this, but I presume one would connect that statement. Sorry, I've seen the words so many times and now I can't even see them. But anyway, I would connect it with perhaps his summary of our pleaded case in paragraph 12. But I don't think he makes that explicit link.
Presumably, the right approach, is this right, would be that the judge in these circumstances would be required to take your pleaded case on breach as the facts.
He goes a bit, and of course, yes, he takes that as the case, and I think that's why I link it with paragraph 12.
And that must be right, mustn't it, Mr. Bowship? Because if you look at 12, he's explicit about what the breach is there in subparagraph 6. By reason of the Council's breach of the final sentences of Article 1083, he has suffered and will continue to suffer loss and damage. So that's the breach he's assuming.
It must be that, I think. And the only gloss on that is paragraph 28C, but that doesn't. That only goes to the Frankovich component, not to what the breach is. It's only, as it were, adjectival rather than defining the breach itself. In In tax cases, there are separate concerns because one is, and Credit Suisse, which he refers to, is of course a case where one ends up looking at the reference framework. But in our submission, that just isn't relevant in a case like this. One isn't looking at how a particular tax applies to all the people who might be affected by it, and to consider whether or not one person is affected differently by the scheme of the tax. The reference framework here is simple. The reference framework is the provision of the scheme for provision of commercial waste in County Durham, and the actors in that framework are the claimant, the defendant, and anyone else active in that market. And in those circumstances, one doesn't need to get into sort of fancy analysis about what is or is not the reference framework. And we were referred to below, and the judge cites provisions from Mrs. Justice Bacon's textbook in paragraph 67 of the judgment, page 377. He noted that we relied upon the simple proposition, an aid to an individual undertaking is obviously selective. And our argument there is, well, obviously the person, the recipient here is the council. There is only one undertaking, the individual undertaking is the one that is benefiting. He then counters with another passage at 2.115 from Bacon, but the reference, particularly when he refers to, in our submission, it supports what we were saying, because what he refers to is the provision and footnote where it says a measure is prima facie selective if it produces advantages exclusively for certain undertakings or certain sectors. This will normally be the case where aid is granted to a single undertaking. The footnote observes that in some cases of measures of individual application, in some cases of measures of there must be a word missing, I'll type it. Anyway, may require a more complex assessment by reference to a relevant reference framework, such as individual tax rulings. Well, that may be the case in tax cases where one's looking at, as it were, a measure of general application, and one looking at how that general legislative measure applies differently to different elements. But here one is simply looking at the application of a particular cost allocation measure undertaken by the council in favour of one entity, its own undertaking. In those circumstances, one does not need to overcomplicate the matter.
Well, are you saying that the fact that your council is subject to a different VAT regime is irrelevant?
Yes.
Why? When that must have an economic effect?
Well, it may be that it will become relevant when one's looking at the overall costings, but the legislative framework under which these entities operate is that provided for by the Environmental Protection Act. All that is relevant for the purposes of the state aid regime is that the council's commercial waste business is an undertaking, and the council is providing, we say, state resources to that undertaking, and that's the only relevant statutory regime that one needs to take account of. It may be that for the purposes of VAT legislation, different rules apply about the way in which VAT may or may not be levied, but that doesn't have anything to do with the way in which the state aid legislation operates.
So the fact that the council gets a tax break, which makes its services cheaper, is irrelevant.
Well,
how so?
That might be relevant when one actually comes to the calculation, but it doesn't affect the substance of whether or not this is or is not a state aid. The legal structure, if it is right that fixed costs are being borne wholly on the home by the home collection business, and some of them ought to be some or more should be properly shared by the commercial business, then that is a state aid. It may be that the precise accounting will have to take account of the VAT position, and the charging would have to take account of that, but that doesn't affect the point of principle. If we are right on the pleading, which in my submission the judge was right to assume that there is a breach, the pleading is, it's regardless of the VAT position. The pleading is that some or all of the fixed costs that should be borne by the commercial waste business are being borne by the home business. And that's got nothing to do with VAT and any special status for VAT. Now, it may be that when we get into the detail as to how much is being charged and whether or not what the distortive effect is on competition and so forth, it may be that one has to do some arithmetic and work out how the VAT position can be taken out of allowance. And at that point, it may become relevant. But at this stage, with the general structural point, it's completely irrelevant. Yes, I mean, to put it put it better, as Junior puts it, it's irrelevant to selectivity. It might be relevant to the costs and the economic advantage. It's not relevant to any question of selectivity. All that the legislation provides is that the defendant counsel can, that the charge that it can impose is subject to a cap. That cap is that the charge must be a reasonable charge. And as I've already said, it must be tried that an unlawful charge cannot be reasonable. If the defendant has assessed the level of the charge on a basis that fails adequately to recoup the fixed costs of that service from its users, so that in effect the defendant is providing itself with a subsidy, that must be unlawful. So it may be that the reasonable charge must take account of a greater allowance of fixed cost on the commercial waste business. But that's a matter of calculation. That's a matter of arithmetic, which we're simply not in a position to do, of accounting, which we're not in a position to do at the moment. None of that affects the proper characterisation of the breach. So try to draw that together under a heading of selectivity, and to some extent, in answering your Lordship's questions, I have to some extent tended to blur the 2 points, and I apologise. But
so we moved on to selectivity.
We're on to selectivity.
Yeah.
But I've to some extent anticipated some of these points already. The starting point on that, it again goes back, he refers to the Bacon textbook. I've already referred to a couple of passages. I must refer to one other, which it's in paragraph 61, which he
Just pausing there. I'm not sure that's in the authorities.
It isn't, and it probably should.
Well, I think it should be, because if paragraph 67 is the key part of the judgment, the only authority to which reference is made is Bacon.
We'll get it.
And so, I mean, there are references dotted about, but I, for my part, would welcome all of it's not a book I have. I mean, we can find it online, but if the sections that are referred to in the judgment are the relevant ones, I for myself would welcome those.
We'll get it done.
Yeah, sorry, so I interrupted. So you were going to 61?
Just 61, which is just the one other passage, where in the context of looking at the Credit Suisse, a tax case, again, the Bacon analysis looks at the way in which selectivity emerges, and as the learned author says, this is starts by saying selectivity is one of the most difficult areas of 1, 2, 3, 4, 5. The basic problem is that not every measure that can be described as producing advantage for one or more groups over others is regarded as selective, and so on and so forth. And the case law has dealt with different types of situation. What I wanted to go to is the very bottom of the paragraph, though, after the 3 dots, because we say this is the situation we're in. It should be emphasised, however, that it is not necessary to address all 3 stages. It's the stages of analysis on selectivity in every case. In most cases, the prima facie selectivity of the measure will be obvious without having to look at a reference framework, and the nature or scheme issue will only arise to the extent that this is advanced as a justification by the relevant member state. All that can be, in this case, there isn't some, as I said, I made the point of reference framework. The reference framework is simply the commercial arrangements for provision of, or for arrangements for collection of waste in County Durham, and one only undertaking benefits from the breach which is assumed. That doesn't require some careful analysis of the reference framework. That is a prima facie selective measure for the benefit of one undertaking. Some of this I've covered already, so in answer to your worship's questions, I just want to check, if I may, that So when the learned judge looks at the judgment of Mr. Justice Warren and the tax treatment, we say that he is looking only at the characterisation of that business for the purposes of VAT legislation and is separate and distinct from the state aid position. The core error is that whatever the tax position might be, under the EPA, the judge is wrong to say that the provision of the service is done under a specific regime. On the contrary, in fact, as we've already identified, that even the defendant is not obliged to collect waste, it's only obliged to arrange for the collection. This is a competitive market. The obligation to arrange for collection is addressed under the regime, but in providing the service itself, the council is another undertaking for the purposes of state aid law, albeit subject to a statutory limit on what it can charge. It is competing as an undertaking, not pursuant to any special regime or framework. And the further peculiar point about this in our submission is that at the end of this analysis, and this is at the end of paragraph 67, where he draws together his thoughts on selectivity.
Well, it is the only finding is the sentence that starts the important point.
The point, exactly. That point seems to me.
This is it.
Yes. He seems to say it's a, and it's odd because what seems to be the point he says he isn't deciding at the very end of paragraph 67.
Well, that comes back to your ground 2, which we'll need to explore. He says it would be substantially unfair for you to deal with the selectivity argument. He then at 67 says that it's strongly arguable.
Yes, strongly arguable that he isn't deciding.
Yeah. But the key point, as I understand it, on selectivity is the sentence that starts the important point made by the council, blah, 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 so its factual and legal situation is not comparable to that of TDC. So what do you say about that?
Well, we say the regime, the point I've just made, as an undertaking providing commercial waste collection, it is a competing undertaking.
Yeah, so that's your point. It is an undertaking.
Yes, and it's admitted that it's an undertaking. Now, it has statutory obligations to arrange for waste collection, and yes, it has statutory duties to make sure that all those broader points about making sure that waste isn't left on the streets in County Durham and so on and so forth, and it will have to take account of that in the way that it makes those arrangements. But there is as we've seen, there are a number of our players all interested in County Durham. It's in the pleadings. Substantial, almost household names. This is a commercial market, and when it is competing against my client, it is not doing so with any special, as part of any special regime. It is just a competitive undertaking. And we say, when it comes, having identified that as the important point, the strongest the learned judge says at that point is that it is strongly arguable, but he's not deciding it. But we say that can't be the right approach to deciding whether the breach is sufficiently serious. It seems to be thinking, well, because this might be a difficult point, and I suppose perhaps it might have been a difficult point which the county may have wrestled with when deciding whether or not this needed to be notified. We say none of that's relevant. The council had no discretion to decide or evaluate whether it was or was not acting pursuant to some special regime or framework. It either was or was not, and he does not decide that matter. He seems to allow simply that because it may be true that uncertainty means that the breach, that because there's uncertainty that the breach is not sufficiently serious. We say that can't be the correct approach. This was not a case where the council had a discretion as to how to comply with the law or discretion in complying with the law, as in my...
The relevance the judge attributes to this point is stated in paragraph 68, which he says is, even if the council is wrong, the position it's taken is not so obviously lacking in merit, it's considered to amount to willful breach of the state aid rules or to be inexcusable. Now, what's wrong with that?
Because what that amounts to saying is, well, the law, there's no, what he's not saying there's a discretion about whether to comply or not. What he's saying is, it may be difficult to decide what the law is. Well, that, in our submission, can't be an excuse. It can't be a way of getting in and saying this is not a sufficiently serious breach. To simply say the selectivity limit is difficult, and this may have been arguable or not, this may have been difficult for the council to know the answer to. But that, in our submission, cannot be an answer to the question as to whether or not the breach was or was not sufficiently serious. Because that seems to be what he is saying. The council may have taken the wrong decision, but maybe they were right. Maybe they were right. We haven't. I mean, there's no at this stage in the case. Again, it's the early stage. There's been no disclosure of what internal.
Sorry, why do you say this is irrelevant to Factor 5 in Negassi? Because Factor 5 in Negassi, or indeed Factor 3. Factor 3 is the degree of excusability of an error of law. Factor 5, whether the infringer was acting intentionally or involuntarily, or there's a deliberate intention to infringe as opposed to an inadvertent breach. So if the law is unclear, then people may infringe inadvertently.
Well, nice. Taking 3, error of those factors are looking in my submission at the other end of the discretion. When one's dealing with legislative discretion, as we know in cases like Negassi, one is dealing with choices about how implementation shall be done. And we know that in some cases it was difficult for the legislator to know how properly to implement the legislation. And excusability was often very much part of those cases because there was an excuse. It was excusable that the implementing legislator did not know how properly to do it, or made a choice in implementing a directive, let's say, and it turned out not to be right. But if one is dealing with a law as here, which imposes an obligation, it doesn't confer on the council a discretion to decide whether or not to comply with the law or how to comply.
So this is your point again, it's black and white.
It's black and white. And if it is an obligation, then to use the vernacular phrase, but it's still true, ignorance of the law is not an excuse.
Well, I understand that, and that goes back to your point that 1 to 4 of Negassi may be of limited application in this sort of case. I get that. But 5 is a bit different, isn't it? I mean, my Lord raised with you 3 and 5. Just focus on 5.
But focusing on 5.
5 doesn't seem, on the face of it, to be so limited.
But it is alternative. So, the first part of 5, whether the infringer was acting intentionally or involuntarily, clearly here, the council was acting deliberately. And our point is, as you know, at a later stage, there was correspondence where we pointed out to them. And we relied upon that in our paragraph 28C. We've said, we think you are in breach of obligation. Now, they may have disagreed with us, but they clearly acted deliberately. They acted deliberately in the way they set up their commercial waste business, the way they ran those charges. They acted presumably deliberately in their accounting position.
You don't allege a deliberate intention to infringe the law on
No.
the part of the council.
No, they weren't involuntarily, they weren't intentional or involuntarily breaking the law. they were acting in a, I don't need to plead deliberate. I think they weren't sort of sleepwalking into the way they set things up. They were acting in the way in which they acted. The law existed. In our submission, it's a black and white law. They weren't inadvertently setting things up in a way without regard to the law. They were, in that sense, acting intentionally. Now, I'm not saying that this is, for example, I mean, again, I may be going a little bit too far, but say a fact-attained type case where it might have been said that there was a deliberate intention to infringe, and there are cases where member states deliberately legislated so as to repudiate an EU law obligation, and that would be that sort of situation. We haven't said that they saw the law and thought, well, let's deliberately breach it. But they weren't acting inadvertently in ignorance of there being this legal regime. It was part of what the local government, what the county solicitor and his department, no doubt, have in mind every day. They knew it was something they would have to accommodate themselves to. So in that sense,
so it seems to follow that your case is one of error of judgment on their part.
Well, they were in breach of law. They were wrong in their assessment of law.
So it was an error of judgment on their part.
Yes, they were. Yes, and so it was. But it was not just an error of judgment. It was they were acting intentionally. They were setting up their commercial business in an intentional way, in a particular way, taking account of what it would seem was an erroneous view of the law. In that sense, it was an error of judgment. But up to that point, they were intentionally acting in a particular way, whether in the hope or the expectation or the belief that they were right in the law. But it was intentional. Now, they're not. There is at this stage no evidence or no case as to what internal consideration there may have been within the council as to state aid law.
Well, if it was your case that the council deliberately intended to break the law, you would have to plead that,
of course,
as well as proof.
Of course we would. And we're not. We
don't allege it.
We don't allege it, and we couldn't. We don't have the material. We simply don't know what happened within the council at this stage. But it can't be right that this is sort of. If the law exists, the local authorities have resources to comply with the law. They can't say, "Well, this is the law. We didn't expect that. It didn't occur to us we had to comply with that, or we unintentionally just sort of steamrolled through that." This is a legal obligation which public authorities in this country were well aware of. We know they received guidance from central government. They must have known it existed. So in that sense, it was intentional what they were doing. They obviously took a view, or one hopes that they took a view about what the legal position was. We don't know. We can't know at this stage of the case what their internal deliberations were because we don't have any such material to rely upon. And it would not be proper for us to make that. But it doesn't excuse the defendant's failure if it turns out that their analysis of such state aid law turns out to be wrong. The fact that there is uncertainty or that it's taking a risk may mean that, yes, it's excusable in the loose sense that one can understand why they took the decision they have, but it doesn't stop this being a serious breach of law. This is a serious obligation designed to establish, going back to the point at which there was a point where all waste collection was a public function. This legislative regime, the EPA, was set up so as to set up a competitive markets. And it is plain from the legislation what it does. It sets up the space in which commercial waste collection can be competed for by private entities. And in that context, it can't be right that the council can say, well, let's say hypothetically, we took a risk or we made an assessment, but it turns out we're wrong as to whether this was or wasn't state aid. In short, we say the right approach is in fact the approach taken by the Commission in the first letter that we looked at, has there been a proportionate allocation of cost? The Commission's analysis, as we say, is the analysis that we, at least going along the same lines that we would take. Have they done that or not? We don't know whether that was done properly within the Council at the appropriate time or not. But if they were wrong and they're in breach of the law, that must, in our submission, be a sufficiently serious breach. This is at the hochtief end of the continuum, not the Negassi end. So those 1, 2, 3, and 4, I think, are all very much about those sorts of exercise of discretion type issues. I think I've covered I've addressed factor 5, I think, in answer to your questions. But 5, 6, and 7 look at the other end. We say the conduct was deliberate. I'm not saying that it was that they deliberately broke the law, but the conduct then it's deliberate in the sense that they didn't inadvertently wake up one day and discover they had a commercial waste business. They deliberately set up, knowing presumably that they were operating within the EPA regime, they set up a business and set up arrangements in a particular way. That was a deliberate action, with no doubt taking a view as to what the right thing was to do, having regard to the commercial circumstances, the law, and so on and so forth. The Council understood that the breach affected the claimant and others in the same position. The claimant had pointed this out, but the Council continued in its position that it was entitled to do as it did. This is not a case of complete failure, rather knowingly proceeding in a particular way to the disadvantage of competitors on the assumption that its analysis of the law was correct. And if the Council did act in breach of obligation, it is submitted that this must be sufficiently serious, having regard to the factors and having regard to where this case must lie along that overall continuum. Uncertainty of the application of the substantive case law does not, in our submission, and should not, provide a defence to the availability of damages as a remedy. If they were in doubt, if there was genuine doubt, they could always notify. That, after all, is one of the reasons why the notification system exists, because, as so often with notification systems, the notification system exists because there may be complications of law, fact, or whatever. The notification system exists, and there was, of course, a prior system to go and discuss the matter with the central government authorities who had the immediate relationship with the Commission in Brussels. So, in our submission, at the very least, our case pleaded in, or case for which we applied for permission to amend in paragraph 28C of the draft amendment is a case for which there is a realistic prospect of success. The judgment should be overturned, and we should be permitted to proceed with this case, bringing 28C into our pleading. Turning to ground 2, having looked at what selectivity involves, I think I can take it fairly swiftly, in that I think the facts are quite clear. The judge decided that it was not open to the Council to pursue its application for summary judgment and strikeout on the basis of its selectivity case, and he sets out his reasoning for that at paragraph 24 on page 356. And he in a sense, the reasons that he gives in some detail in paragraph 24 don't particularly matter for the thrust of my point. He's decided that this argument cannot be proceeded with at that stage, and he says the best reason for allowing it to proceed is that below I did still have a go at responding to it. But he still decides that it cannot be relied upon properly as a ground of summary judgment. But he still takes that into account, as we've seen, when it comes to the sufficiently serious point. And he says, well, the very point, the selectivity point, which he's decided should not properly be taken into account on the summary judgment is now to be taken into account and appears in fact to be the decisive factor in deciding the sufficiently serious breach point against us. And we've seen that, and Lord Justice Coulson has already taken me to those points, but in paragraph 68, where very briefly he essentially says, well, the point that, again, I'm summarising a number of points together, but essentially the point that I've said they can't run against you separately as a summary judgment still seems to be a point which, taking account of it, may be a point which is difficult. Because it was difficult, this can't be a sufficiently serious breach. In our submission, that cannot be right. If the selectivity point in issue could not properly be brought against the basis of the summary judgment claim, it cannot be the basis upon which the Frankovich point is decided against us in a way that brings this claim, at least the claim for damages, to an end. And that, in a sense, I don't think there's much more to be said about it than that. I mean, one can unpack the detail of paragraph 24 as to how he reached that point, but in our submission, there's no challenge to that decision. That's by my learned friend. It's not suggested that point should have been kept alive. It wasn't alive, and it therefore should not sort of come back and in the way that it was brought back by the learned judge.
Can I just ask about how this all happened? There was obviously a debate before the judge about whether the selectivity argument was open to the council. And as we see at paragraph 24, the judge concluded that it wasn't. Was it the provision of the judgment that was the first indication of that, or did the judge indicate that at the start of the hearing?
Sorry. Mr. Robertson,
My recollection is that I argued that I should be allowed to advance it as a self-standing ground for granting summary judgment, and the judge decided to reject that in the judgment. In the judgment? Yes.
So
advanced submissions at the hearing.
Yeah.
It was not going down at all well, so I moved on to the
fine. So
excusability or
all right.
otherwise.
Well, that's very helpful. So you found out effectively what the result was when you got the judgment.
When we got the draft judgment.
On this point.
Right.
Speaking entirely for myself, had it been me, I'd have spotted the point, I think, and I would have got that dealt with at the outset, and I would have said, either I'm going to adjourn this case or we deal with everything. You've got 15 minutes. It's probably why I'm not missed on the first instance bench, but that's what I would have done. But that didn't happen. The points evolved during the hearing and you got the result in the judgment.
Yes, a lot happened at the 11th hour because my learned friend only applied to amend.
I understand that. Yeah, no. I understand there was a degree of, well, there was quite a lot of 11th hour stuff. Yeah. But anyway, that's what happened. All right, that's very helpful. Thank you very much.
I don't know if on top of the facts, I don't know if I can assist further, but I would agree.
No, I just was interested to know how it had come about.
One can pick at it. One has to reconstruct a little bit more of the history from the skeletons for that hearing, which are in the bundle, and you can see what wasn't in the skeletons, as it were, and what was not.
Yeah, it's really what the judge, how the judge approached it, and that's been explained. So
and I don't know if it's relevant or not, but this was a wholly online hearing, so whether that makes any difference, probably does actually make a difference in the way in which the hearing worked, because there's probably a disinclination to have lots of little breaks in a hearing where you've finally will manage to get onto Teams.
I don't think we can take that.
No, I just don't know. Well, maybe I'm trying to stick up for the learned judge.
No. It's just different styles. It's not a criticism of the judge at all. Okay. Anything else on ground 2?
No, nothing else on ground 2. So just ground 3. The judgment says the declaratory relief would be of no more than historic. Sorry, on declaratory relief, the Frankovich test does not apply. we're entitled to declaratory relief in respect of a breach, we would be entitled to it without having to go through the Frankovich hoop. The learned judge says declaratory relief would be of no more than historic interest. He says that at paragraph 75, on the basis that the declarations would have no practical consequences in terms of the redress of past wrongs and would have no prospective value where the legal framework to which they related no longer applied, and that's in paragraph 75. At the time of this hearing, it was not, you'll see from the date, it was November 2020, and you'll have picked up from the judgment that there was a certain amount of discussion between at the court about what regime might apply following exit from the European Union. That position has, of course, moved forward substantially further. It is now reasonably clear that there will be a subsidy control regime, and we have provided extracts from that at tab 3 of the authorities bundle. This bill is, I think my last bill, I think, was in the second reading of the Lords. It's been through the Commons and is now in the second reading of the Lords. So it might very well be that there have been changes, but since this version was put into but I don't think it'll make any material difference. But if I can just take your lordships to it very briefly, the contents page is at page 37 of the bundle, and that is the version, I think, December 2021, which is fairly up to date. I don't think any major changes since then. Subsidies are proposed to be regulated under this regime as provided for in section 12 on page 49. Section 12, page 49, a public authority, and the defendant will be a public authority for this purpose, must consider the subsidy control principles before deciding to give a subsidy. So there's not and must not give the subsidy unless it is of the view that the subsidy is consistent with those principles. That's section 12. There's not a general prohibition, but there is a requirement on the public authority to consider how to go forward. And certain kinds of subsidy are expressly prohibited, but I don't think they're part of this, would be part of this case. They're elsewhere. We're in the, as it were, the discretionary part. At section 70, there is and that's on page 81. There will then be an enforcement mechanism through the Competition Appeal Tribunal. There's also a mechanism through the Competition and Markets Authority. But there will be a direct CAT-based regime for challenging the grant of subsidies. And the subsidy control principles, which must be had regard to, are at page 93 in Schedule 1. For example, F, subsidies, so it's the whole of Schedule 1, which goes over, it's page 93 and there's a bit of 94. The key principle here would probably be subsidies should be designed to achieve their specific policy objective while minimising any negative effects on competition or investment within the United Kingdom. And then there's a provision about beneficial effects to outweigh negative effects. So those are the principles which have to be had regard to. A subsidy is defined in section 2.1 of the bill in a way that very closely resembles Article 107.1 TFEU. That's at page 44. but obviously without the, it's a rather lower bar in the sense that it's no longer an effect on trade between member states, but an effect on competition or investment within the United Kingdom. That's section 2(1)(d). Sorry, I paraphrased again, a slightly longer provision, but it's a UK-based test, not an EU-based test. And there's further reference in section 3 about how to determine what is an economic advantage. Section 3(2). Sorry, section 3(1). This section makes provision about determining whether financial assistance confers an economic advantage for the purposes of the definition of subsidy. Section 3(2). Financial assistance is not to be treated as conferring an economic advantage on an enterprise unless the benefit to the enterprise is provided on terms that are more favourable to the enterprise than the terms that might reasonably have been expected to have been available on the market to the enterprise.
So undertakings become enterprise,
yes,
subsidies instead of state aid.
Yes, because we can't use the old words.
I appreciate
Sorry,
that.
that's a political point I should make.
Yeah.
We have to use new words.
But are you disputing that this is a new legal regime and intended to be such?
It is a new legal regime and intended to be such.
And
but
reference to case law of the Court of Justice will presumably be forbidden.
not forbidden, because it is in. This is a regime which implements in part obligations under the Trade and Cooperation Agreement, and so there will be potentially issues tracking back through the TCA, but more significantly, it is plain, one only has to look at its terminology, that it is a regime that is closely modelled on the EU regime, albeit in some places the vocabulary has changed. Very similar issues are raised. It is directed at the same mischief as the current regime, albeit in different formats with different enforcement procedures, and so on and so forth. But it is clearly designed to address the same mischief. And to put it crudely, the breach that is assumed in this case, the cross-subsidisation, if it is unlawful, if the cross-subsidisation in the past had been unlawful under the EU regime, that would be, we say, relevant to future conduct under this regime, because it will be.
But you can't say that a finding of state aid contrary to EU law would ipso facto lead to the conclusion that it was a breach of this act if it becomes.
No, of course not. No. But what I can say is that if one was looking at how the principles were considered, how the council conducted itself in deciding to deal with the subsidy, and so on and so forth, in all of those respects, it would be relevant. It would be highly relevant to have a judicial determination as to whether or not its previous conduct under the EU regime had been compliant with the EU.
So that's the court giving the council advice as to its future conduct.
No, it's the court. Well, it is the court determining a live dispute between two competitors. A live dispute as to whether or not there has been cross-subsidy. We say, if we hadn't left the EU, there would have been no reason for this declaration, for this case for declaratory relief not to proceed. That was the only. It's only because we left the EU that has gone. It is the ongoing competitive relationship between the claimant and the defendant in the commercial waste market. It still exists. Issues still exist, and determining whether or not the way in which the council had dealt with that market and dealt with itself, its own undertaking, and ourselves in competition prior to exit, and determining whether or not it was compatible with law or not, will be relevant not only to establishing that prior relationship, but would certain. Well, it wouldn't be relevant; it would be determinative. But it would also be relevant to understand if it was unlawful then, that would be a factor which presumably would have to have been taken into account by the council in considering how to deal with the subsidy principles when dealing with the new regime when it comes into force, presumably in the forthcoming months. It is not irrelevant. It is not immaterial. it is not purely academic. It is not purely theoretical. This relationship and this market continues, the EPA continues, my clients continue in business in County Durham seeking, we say continuing to be disadvantaged substantially by the actions of the defendant.
Let's assume that this bill becomes an act fairly shortly, so it will therefore be UK law. What would be stopping your client from commencing fresh proceedings alleging a breach of this act, if it so chooses?
Well, nothing. We could bring that claim, but for example, we would.
And why would that not be the proper context for the resolution of any ongoing dispute as to cross-subsidisation?
Well, that would be a context in which to do it, but inevitably one would be looking at how the accounts had been set up, how the parties had competed, and the court would, the parties would be providing, for example, disclosure as to how they had acted, how they had dealt with each other in that market, dealt with the business, and the council would be giving disclosure as to its decision-making and its approach to the subsidy principles, presumably. And in that context, it would, whether one's talking about a duty of candour in public law terms or disclosure in private law terms, it would have to be relevant to the decision making for the council to say, well, this has been an ongoing situation for some time. In considering our compliance with the new Subsidy Control Act, which presumably it would be by then, we would have had to have considered how we dealt. It would not be a fresh situation because they would be looking at what decisions it had previously taken and what advice it had previously been taken, and if it had changed its position and taken a different view or the same view, what that previous advice was. It may simply say, we took advice on the old regime and we think the regimes are so similar that we can just roll the advice forward. So, that in itself would be highly relevant, because in those circumstances, it would be highly relevant to see whether or not the situation, which the council says is very difficult and is its basis for, on which we say it's excused from it being a sufficiently serious breach, it would be highly relevant to have that position determined so that it could understand going forward what that position had been. And just as any declaratory relief is only, it does no more than declare the position, but it does declare that this, taking account of the previous facts and the previous market relationship, that was unlawful under those rules, and that is relevant to considering, the council considering how it goes forward under the new rules. It's got to be relevant. And the case law of whether or not, and I would submit that the case law of the Court of Justice, I mean, I'm sure there will at some point be a contest about this, but it is not the case that reference to CJEU case law is forbidden. The English courts might not be bound by CJEU decisions, but if and to the extent that it can be seen that the two regimes run in a similar direction, it may be relevant to take account of the CJEU precedent, just as it might be relevant to take account of the precedent from another court system if they had a relevantly similar regime. The likelihood is the only relevantly similar regime is going to be the EU system. So both in terms of understanding the Council's own assessment of its future position, and also in understanding the correct approach to what the Council says is a very difficult question about selectivity and other matters, no doubt, on all of those matters, determination of the position would be relevant. And to take another example, clearly an issue has arisen as to whether or not, as to which we're not in a position to take, as to whether or not there's been a proper allocation of cost, whether that cross-subsidisation has probably been properly addressed. We're not in a position to address that in our pleaded case at the moment because we don't have the material. But that is going to be an ongoing issue for them for as long as the parties are competing in the market in the way they are. And if the parties can determine, if it can be determined whether or not the process of allocation of cost, of fixed cost, was correct under the old law, that will be more than relevant, and if not determinative for the future. And that is very likely to preempt the need for there to be any future proceeding. That's going too far. There must be a reasonable prospect that it would prevent the need for any future litigation, because we actually have some real facts in the past which could be examined and determined and decide whether or not a proper allocation has been done. If that analysis can be done, then, and the court can lay down guidance, it may very well be that the council and my clients are able to understand each other's position and move forward without any need for further litigation. But to simply say, well, the answer is that we should bring fresh proceedings under the new legislation, in my submission, it doesn't deal with these potential relevance of the past facts. So we say there could be more. That this is certainly not purely academic. There is real prospective value in declaratory relief, real relief, prospect of such relief being granted, real commercial significance to the Durham Company, my clients, and we say also real significance to the defendant, because any judgment is likely to be of value, actually, your lordship puts it, in advising the council. But it's not just the court acting as an advisor, it's acting that the court is determining whether or not it has acted lawfully or not. That's the point which the council says is difficult. And if this is the way in which it can establish the resolution of that difficulty, then so be it. But there is nothing inherently wrong in that. And if that is the situation, then declaratory relief is far from academic. I've gone on longer than I intended. I don't think there's anything else I can assist with.
No, thank you very much, Mr. Bashir. No, that's fine. You finished by lunchtime, like just before. Mr. Robertson.
Well, Lords, I'm going to take the grounds in reverse order. Ground 3 first. Hopefully I can deal with my submissions on that before lunch. Then after lunch I'll turn to grounds 2 very shortly, then ground 1.
Fine.
Ground 3, declaratory relief. Essentially they refer to the Subsidy Control Bill because they want to keep alive the argument that they ran below that a declaration as to their state aid case will still be of some relevance despite Brexit. We say this is not the case for 2 principal reasons. Firstly, the bill gives effect to the UK's obligations under the Trade and Cooperation Agreement, as my learned friend said. That was signed by the UK and the EU on the 30th of December 2020, a month after judgment in this case. The Trade and Cooperation Agreement establishes a bespoke subsidy control regime which applies between the UK and the EU only. My learned friend's taken you to the UK's intended implementation of the TCA in the Subsidy Control Bill. It's not a facsimile of EU state aid, but it's not wholly dissimilar either. The Article 372 of the TCA says that each party shall ensure that its courts and tribunals are, among other things, competent to review subsidy decisions taken by a granting authority for compliance with that party's obligations under the subsidy control provisions. The obligation that courts are to be able to review subsidy decisions is given effect by Section 29, subsection 1 of the EU Future Relationship Act 2020. And that Act received royal assent on the 31st of December 2020, and Section 29 came into force at 11 p.m. on that day. So since then, the UK has an interim subsidy control regime giving effect to the TCA. And that'll be superseded when the subsidy control provision subsidy control bill becomes primary legislation, which the sponsoring department, Bayes, says will be in the autumn of this year. Now, the first reason for rejecting an action for declaration is that it would be irrelevant to the bill. This is because the bill is informed by the TCA. It is not informed by, still less governed by, concepts of EU law. And the learned judge was aware of that because he referred in paragraph 2 of his judgment to the House of Commons Library's briefing paper of the 19th of October 2020 on UK subsidy policy first steps, which I put in response to my learned friend's submissions that EU law will somehow continue. And that states that WTO rules, World Trade Organization rules, not EU law, is intended to apply in the post-EU state aid regime. Of course, at that point, at the point of the judgment, the TCA hadn't been finally concluded. And it was still open to doubt as whether it would be. Fortunately, it was. When you look at the governing law, the governing provisions of the TCA, Article 4 states, the provisions of this agreement and any supplementing agreement shall be interpreted in good faith, in accordance with their ordinary meaning, in their context, in light of the object and purpose of the agreement, in accordance with customary rules of interpretation of public international law, including those codified in the Vienna Convention on the Law of Treaties, done at Vienna 1969. For greater certainty, this is paragraph 2, neither this agreement nor any supplementing agreement establishes an obligation to interpret their provisions in accordance with the domestic law of either party. Now, that's carried over into the bill. If you go to Authorities Bundle, tab 3, page 92, clause 89(2).
Hang on a minute, tab 3 is this again?
It is, yes.
Tab 3, page
92.
Yeah.
Halfway down, section 30 of the EU Future Relationship Act 2020, interpretation of agreements, public international law, applies where a court or tribunal has regard to the trade and cooperation agreement or supplementing agreement for the purpose of implementing a provision of this act. Section 30 provides a court or tribunal must have regard to Article 4 of the TCA, public international law, when interpreting that agreement or any supplementary agreement. So, my lords, that makes it clear that the interpretation of the TCA, and hence of the implementing provisions of the Subsidy Control Bill, when that becomes law, is not governed by EU state aid law, or indeed by domestic UK law for that matter. It's public international law, the Vienna Convention, and there is in fact an international regime to which the UK is now a signatory on subsidies. That's the 1994 WTO agreement on subsidies and countervailing measures. So the Subsidies and Countervailing Measures Agreement, 1994, it came into force as part of the Uruguay round at the beginning of 1995. Originally, the UK was bound by it through EU membership. Since Brexit, the UK is now a party in its own right. So in our submission, it's impossible to see what assistance to the interpretation of the bill could be derived from a direct declaration on EU state aid law, when the bill is to be interpreted having regard to the TCA, which is in turn governed by public international law. The second reason for rejecting a declaration under the bill is that the appellant already has a potential remedy under the TCA as given effect by section 29(1) of the EU Future Relationship Act 2020. It could have brought a judicial review claiming that this arrangement constitutes a subsidy to the council. But they've chosen not to bring that judicial review. Now, this isn't a fanciful suggestion. 2 weeks today, I'm in the administrative court defending the Department for International Trade against a judicial review brought by British Sugar, who claimed that new tariff arrangements for the imports of raw cane sugar for refining constitute a state aid to its principal UK competitor, Tate and Lyle. So you can bring a judicial review, they just haven't done so. I should add that for the future, and this is just to show I've done my research and I've read the Jersey Choice judgment, the Frankovich damages claims in any event cease to be available at the end of this year for the reasons set out in the Court of Appeal's judgment of the 17th of December at the end of last year, judgment of Lord Justice Green, with whom Lord Justice Arnold was one of the agreeing judges. So, declarations for the future, EU state aid law, that's not for the interpretation of either the TCA or the Subsidy Control Bill. We're now in the world of public international law and compliance with WTA rules, as the judge had indeed appreciated from the House of Commons briefing paper that he quotes in paragraph 2 of his judgment. My Lords, if that would be a convenient place to stop, I finished all I have to say on ground 3 and I can resume on ground 2.
Right, all right. Well, we'll start again on ground 2 at 2 o'clock. Thank you very much.
Coulson.